Okay. Good morning. I'm sorry, good morning?
Good morning.
Losers. Okay. Okay, so again, just welcome back and thank you for being here. Because it's your choice to be here. So, thank you. Again, my premise, right, is this is not just about the LSAT, that if you reason the way that a lawyer is taught to reason, and the test is testing, do you reason this way, which is what it's doing, is how does your LSAT score not go up? So part of what we're doing is saying, if you can just become aware of what the difference is, it's not politics. It's the way we're trained to approach matter. It's really very straightforward. So, you know, you all get that in June, but likely in June, the Supreme Court's going to come down with a decision on whether or not the administration's policies with respect to the continuation of I don't know whether it's called the DAPA program or the DACA program, I think there are two programs, but do you get that likely in June, the court's going to give a ruling on whether the administration's termination of the prior administration's program is constitutional. Talk to me. Do you get that's coming? Yes. Okay, and that's this case, yes? So, in June, I'm referring to June, there'll be a lot of discussion about this. There'll be a lot of folks who are coming from the heart. Would that be fair on both sides? Do you get that? And but you want to be a lawyer. So it's not that you're not in denial, right? You're not in denial of the views you have. But as a lawyer, don't you have to understand what the law allows and what the law prohibits? So can the law allow something you would prefer it to prohibit? And can a law prohibit something you would prefer it to allow?
Yes.
And that's the lawyer in you. You with me? That's where your view on this, I could care less. Because again, in the world of law, you're going to get up and present your case, and lo and behold, someone is going to get up on the other side and present the alternative case. Do you get that?
Yes.
And that's, to me, so healthy. Because we can shut down. You know, we can have our own views. It doesn't matter what side the views are. We just get our view, we like it, and then we shut down. Right? That's not what lawyers do. So, I've just begun listening to this case, but wouldn't it be swell if in June you understood more about how the court arrives at its decision, really understood it, than the folks around you who are either, just jubilant because the court came down on their side, or despondent because the court came down against them? Wouldn't you prefer to be in a position where you understood the court's reasoning? Talk to me.
Yes.
So that you're not then just saying, well, these justices, well, they're no good, or these justices, well, no, what was the reasoning? So you get, that's the transition. You put aside your view.
Right.
And it's essential because some, and I think many of us can't, or won't. But when you don't, do you get that colors how you read the law? So, look, I've just listened to I just on the way down, I just heard the Solicitor General, so it's just the first 30 minutes that I've listened to. If you can, it is a little weedy. You will have to listen to it several times to get much out of it. But if you can just stick with it, do you get that there is a law, right? That the Department of Homeland Security has a law, that's written. You with me? Okay. And that law prohibits or allows certain things, yes?
Yes.
Okay. And the court reviews the proper implementation of a law, that if a law is unconscionable, if a law is violating, say, a First Amendment interest or some other interest, you get the court is in a position to review the law to see that it's constitutional. We had a law that it was okay to have a country that was separate but equal. Well, we had that law. But the court's role in that is to say, but does that law violate some other principle? So if you listen to this, you're going to start to, I think one thing's going to happen is you're going to start hearing that these 9 justices reason pretty well. They reason from different perspectives, right? But they reason pretty well. They reason very well. The 8 that speak, and I'm sure Justice Thomas reasons very well. He's not participating. So if you can just begin this process, right, of listening. So the first person you'll hear is the Solicitor General, and you don't start going boo because he's part of the present administration. Just like you wouldn't have listened to the Solicitor General 4 years ago and have said yay because that person is part of the administration. You get, that's what you got to lose. You got to go, what is the law? Does this comply with the law? Is this consistent with the law, right? If it is consistent with the law, then the only other issue is the law unconscionable. Does the law do something, that is going to compel the court, which is not a legislative branch, you get that, right? The court's not there to legislate, yes?
Right.
I mean, you may wish it to legislate, but do you agree that the Constitution does not give it any legislative power?
Yes.
And can you amend the Constitution?
Yes.
So if you want to amend the Constitution, what should you do?
You gotta go back to the legislature.
Right, amend it.
Right.
But short of that, that's where we are, right? So one issue is, what is the law, right? And that will be recited to you. 2 is forget the name of the administration, forget its noun, forget Obama, forget Trump, and just concentrate on the administration, like you didn't know who the president was, right? And say, oh, okay. Well, does the action comport with the law? And then if you say yes, that gets a little check mark, right? And then the only other issue is, but is the law unconscionable? And how expansive do you get with that? In other words, what is the proper role of the court? If the Congress has passed a law, what are the limits on the court? At what point do you say a court really should not, except in extraordinary circumstances, be overturning the laws of the Congress, which are made more directly through the people? Just, again, if you can just begin to listen clinically, you're changing one of the elements, which is, again, on the LSAT, this really is about reading textually. So really what I'm saying to you is, one way to begin to read textually is to hear textually, is to listen textually, right? Lose your view. Is it fair to say when you're a lawyer, you are not going to be compelled to work for any employer? Is that fair to say?
Correct.
And is it fair to say you're not going to be compelled to work on behalf of any cause you disagree with? Is that fair to say?
Right.
Oh,
Not necessarily.
frisky. So then you can take this skill you have developed, right, of being clinical, and go work on behalf of a cause that speaks to you. Yes? And aren't you going to be more effective on behalf of that cause if you first are clinical? Yeah, you bet you are. Because you have to understand the other side, and preferably not demonize the other side, or at least not demonize them until you've heard all their reasoning. So again, this is DHS versus, DHS is Department of Homeland Security. That is the Regents of the University of California, and they are the ones who brought the case. and it involves 700,000 recipients under the DACA or DACA program. Right? And whether or not, you know, in a nutshell, whether or not the present administration has the legal authority to reverse an executive order entered by the prior administration. That's really the issue. Right? Prior administration issued an executive order. It had nothing to do with Congress. They issued an executive order. This administration said, you know what? We don't like that order. So we're reversing it. That is the issue before the court. Okay? So just, if you can begin to do this, one of those elements is changing, meaning you're changing the way you listen. You're now listening, really seeking to understand. Not seeking to pass judgment just yet. Get the facts and then pass judgment, right? But get the facts.
Has it happened before?
I'm sorry?
Has it happened before where one administration did an executive order and then the next administration decided they don't like it?
I have no personal knowledge, but I would be surprised if it had not happened before. I'd be very surprised. Executive orders are just that. But executive orders typically don't involve an agency. All agencies have laws. They have they're regulations, but they're laws. And the difference here, what's curious here, is that the prior administration restricted the agency's enforcement of its own regulation. So DHS had a regulation with respect to immigration, right? Okay. And the prior administration signed an executive order directing that DHS not enforce its regulation. So that is kind of unusual. It would be separate if it's unusual for sure. So I don't know that that's happened before. And that is the nature of the objection from the present administration is, does the executive branch have the authority to, because now DHS is in the executive branch. It's administrative law, right? But administrative law is set by Congress. The boundaries are set by Congress. And Congress basically has delegated everything to the executive because that's what they've done.
It's reminding me of a case that's happening now with marijuana in Colorado and certain states passing the laws, but the federal law it's still illegal.
Right. The federal law trumps, no pun intended, state law. But this is a little different. This is not state and federal law. This is the Congress sets the law. The administrative branch is just running its department, right? But they're running their department presumably consistent with the law, right? Here we have the executive instructing the administrative department, DHS, well, yes, you have this power, but I'm directing you not to use it. I'm directing you, do not use this enforcement power. It's like saying, by analogy, it's like saying to a police department, right? Yes, you have the power to arrest, I'm directing you not to arrest. So the present administration's view of that is, aside from just objecting to that it itself never would have done that, they're also raising the challenge that is that a power that the executive has. Can the executive say to an administrative agency, no, we're telling you you can't do this, when that source of this, that power itself comes from the Congress. So that's what I'm saying. This has nothing to do, in my mind, with the noun of the administration. This has to do with what's going on. And if you can make that change, and then if you're passionate on one side or the other, go work for the side you're passionate on. But for you to succeed, you're going to have to understand what the facts are, right? Because you're going to be confronted with somebody from the other side who's presenting you those facts. So.
Congress, therefore, they should have changed the law instead of just having executive power over it, if he really wanted to implement that as a law.
When you say they could have changed.
Congress, I'm thinking.
Congress could, yes. Congress, and again, there's just history to all this stuff. For whatever reasons, right, the court started this all. Korematsu is one case. There's a case before that, like from 1898, having to do with Chinese immigrants. But the court got the ball rolling with, in matters of immigration, we're deferring to Congress. So courts not played a significant role in this by their own choice, right? Congress now has really kind of said, well, you know, we've written this general law and we're leaving it to the administrative departments within the executive branch to interpret that, right? So now it's in the administrative branches of the but that's the executive, right? That's not the legislature. And so if you go to the EPA, well, you know, it's one thing if you're directing the EPA to do something they're authorized to do, right? It's a very different thing in my mind if you're saying, well, you, the EPA, are authorized to do this and we forbid it. I need to know more about that. And again, you've got to lose the proper noun. And I really do think that's the tough part about this business, whatever side you're on, and hopefully you're on the side of reason. If you can just get that out of your mind and say, but what is the law? And then you have a second analysis, does the law itself need to be changed? Because it's Brown versus Board of Education. I don't care that there's a law that says it's separate but equal, it's unconscionable. But that's a separate argument. And in matters of immigration, the court has not gone there very often at all. So insofar that if you can do that, you will begin reading the LSAT the way it's actually intended to be read. I promise you. And you will be preparing for law school. I absolutely promise you. And when June rolls around and the court has a decision and you're listening to other people who are speaking from the heart, who are beyond a well-meaning, on both sides, it doesn't matter. It's probably going to be a 5-4 ruling, maybe 6-3, but it's not going to be overwhelming, I don't think. But you're going to find you're listening to other people who are, again, honest, and they're not doing anything wrong. But you're going to listen from a very different perspective. And at that point, you'll understand you're now a lawyer. I mean, you may not be practicing yet, but you're a lawyer. Because we hear that, right? We understand it. We get the hard part. We have the hard part. But that goes with who am I working for? On whose behalf am I taking this case? It's completely up to Peter. Right? So if you can begin this, again, it's a little weedy in the beginning, but if you can do it, that would be again, I'll be more than happy to come in here for the first 10 minutes or 15 minutes or so. I'll be happy to discuss anything you have listened to that comes from the Supreme Court. And again, I urge you, as you go through this, and we're working on analogies and examples and counterexamples and hypotheticals. Every single class we're going to be working on that. You're going to hear 8 of the 9 justices on the Supreme Court use analogies, hypotheticals, examples, counterexamples, and you're going to get it's all the same thing. But they're not coming at this like politicians. They're coming at this, it seems to me, as 9 people really trying to figure out what to do based on reason, not on politics. So that was my little intro. You still want to stay? Go figure. All right, well, Anthony's here, so I'm going to hold off, and I'll return. Hello.
Hello.
Hi, how are you?
Good, how are you? Good to see you.
Good to see you. Let me turn this thing off. You want to be on or off?
We'll go off, I think.
Okay.